What's up, people? It's time to get served. It's your boy Phil. How we doing, people? Happy Humps Day. And boy, the U.S. justice system provided us with enough humps today for the next Wednesday and Wednesday and Wednesday after that. It wasn't like one really funny thing, but it was just a continuous, consistent hump after hump after hump. And when I mean hump, I don't mean it sexually. I mean, oh my God, what's wrong with this guy? We also have a juvenile that is astonished by the size of books. And we have Webster, Simpson, good old Thurston. So what's up, guys? How we doing? Let's have some fun, people. Let's start the show with Judge Middleton. How we doing, everybody? Let's have some fun. Let's roll.
Move, and they served a notice to quit on you on February 1st. As a defendant in a landlord-tenant proceeding, including a termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. I did send you that information on how to contact legal aid. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is not, we would take a different course of action. If the plaintiff is agreeable, the Citizens Mediation Service.
What's up, Muscle T?
Possible source of case resolution. If both parties are agreeable to mediation, the court can help set that up if you contact the court. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you would waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You could move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge did not find in your favor, the original judgment would stand. Mr. Larkins and his manager have just checked in. The Camerons are here a little early, and the 115 case didn't show up, so I went ahead and advised them of their rights.
Awesome.
So we can just get right to it. Mr. and Mrs. Cameron, your landlord wants you to move. What's your position?
Someone change the smoke alarm.
Well, Keystone was supposed to help us. When they said they were going to, they told both me and the landlord they were going to pay 3 months back, 3 months ahead. We had an agreement as far as the rest of it went. Keystone didn't hold up their end of the bargain. We had a meeting with them. I had to leave the office. I was so flabbergasted when they said they weren't going to pay. Why would they have told us that and not do it? That's just all I was wondering about it.
Then we got so behind that there's no way to catch us up.
Who's that?
Well, it doesn't look like the rent's going to get paid.
No.
He's not even asking you to pay the rent. He's just asking you to move. They served a notice to quit on you February 1st, gave you until March 1st. Now it's April 12th. But if you're not,
Welcome, Tanya.
at this point for rent, they just want you to move.
Well, Judge, I spoke with Scott earlier. I've been approved for a housing voucher. I don't know what he discussed with his office manager, but that's a possible conclusion. I am going to get on the phone with Keystone as well after this meeting.
Well, the law requires that I adjourn this matter for at least 7 days. This is an unusual day. You don't know because you don't come much. We don't usually do landlord-tenant cases on Wednesday, but I'm going to be going on a trip, and I don't want to get too far behind.
No.
Sure.
Mr. Larkins, I apologize, but the next available landlord-tenant date see what this is.
This is hump number 1, by the way.
Is 10:30 on Friday, April 28th.
It's funny, Tupac.
All right. (10:30 a.m.)
Yes.
Yeah.
Now,
Okay.
that will give you 16 days to see whether you can work something out. When you come
Okay.
next time, don't wear a sleeveless
Oh, I
shirt.
apologize.
Come as though you were coming to a court hearing and
No
treat
problem.
the matter with some respect.
I
But
apologize.
Hump
If
number
you and
1.
Mr. Larkins can work something out, great. If not, you're gonna get 10 days from April 28th to move out.
Okay.
Um,
I'm in
There
agreement
was a
with that.
period during COVID
I'm
where a
glad
lot
you
of
are.
people were getting their rent paid by Keystone or some other agency.
Mm-hmm.
And that money is mostly all gone. So we're back to the period of either pay your rent or move.
Oh,
But
absolutely.
right now, every month you're staying there, he's losing more money.
Mm-hmm.
He's got somebody ready and willing to move
Lady
in,
Humps as well.
$860 per month. So, Mr. Larkins, have you talked to anybody from Keystone or any other agency, or Kristen, have you?
Honor, we're not even taking any money from Keystone on a regular basis anymore because, like on this case,
It's so
they-
disjointed, yes.
they told us they were
But-
going to pay it, and then they did. They honestly, I mean, I feel for them too because they did say they're going to pay it, and they didn't.
They also said that Thomas and Martha didn't finish their end of paperwork and that they tried contacting them and weren't successful.
So,
All
I mean,
right.
they owe us a bunch
it's-
of money from other things too.
Yes.
So,
All right, well, then you may well plan on moving, but unfortunately, I have to go 16 days rather than 7. So that's the best I've got. Friday, April 28th at 10:30. We'll be by Zoom like this, wearing appropriate clothing.
And you
All
got
right,
it. I apologize
I'll
again.
see you. All right, thank you.
We'll see
Thank
you then.
Mr. Lyon. All right, I'm sorry about the delay.
no problem.
Okay, so let's address this McNally situation. So I had typed his name in. I didn't see him on my side with the stream. Then Mrs. Fields had emailed me today and asked me if I heard anything. So by the looks of the poll, this is all wishful thinking. I know we have a lot of viewers from Michigan, around that area. If you guys hear of anything, it's not the 33rd district because Coleman Hessen's stuff is still up. So I don't know if it's just McNally's court, but I tried. Did anyone try looking for his channel today? Because I typed his name in, I didn't see it. So did he pull the channel? Is it getting revamped? I mean, what's going on? I will be seriously depressed, and I'm sure I won't be the only one if Judge Dad is gone. I'm going to be very sad at this point. Yeah, we need the emojis. We need to get in contact. What is going on? I hope he's okay, first of all. And then second of all, is he continuing the stream? He never seemed like he disliked Zoom. So, I don't know. If anyone sees anything in the comments, leave a comment. Did you case with the guys? No, John Boone. That would have been awesome. If you could find it, I will play it and give you credit for it. Oh, my God. All right, let's roll. I told you, hump number 1, guinea tea. Okay, here we go. All right, let's go. Number 2. All right, so we're getting warmed up. Let's go Simpson. Let's get a little Simpson going. This is from today. This is from my boy, The Way I See It. I was busy at work today, and my boy, The Way I See It, always has great clips. If you're not subscribed to him, he posts 4 or 5 times a day. I mean, he posts more than me and Kitch combined sometimes. He's an animal, and all his clips are great. So go check him out. It's The Way I See It. All right, here we go.
People versus Isaac Ellington.
Just give me 1 second, guys. Just pull it up for you.
Assistant Public Defender Cosimo Bessi on behalf of Isaac Ellington. Mr. Ellington, could you unmute and state your full name, please?
Isaac Ellington.
Mr. Ellington, did you get a chance to review the PSI that I sent you to your email?
Yes. Yes.
Are there any corrections that you want to address?
Yes. A community pressing. I was never doing drugs. I got a friend, high school friend of mine. I've been trying to stop him for him doing drugs. Hold on. Stop him for doing drugs and taking in drugs from him. And in the next couple of days, he passed away. I've been clean. I was dropped yesterday. I've been negative. I've been clean. I just lost a good friend of mine of the drugs, and he never woke up, and that's why I got the positive.
So you're saying you didn't do drugs?
No, I didn't do drugs. I didn't do drugs, and I got one
Is this
positive
it,
in
Boone?
April, and I was like, and another one. I've been.
So you're saying positive for cocaine's, aren't you?
No, that's not. It's me because I'm taking it from my friend. He passed away now a couple days ago.
This is it.
You took it from your friend, and then how did it get into your system?
It probably because I touched it. It's the difference if you use it.
Oh.
And I'm taking it from
Oh, so you touched the cocaine, and then you tested positive.
Yes. Then
Oh.
yesterday I was negative.
Okay, is that the story? Is that really the story you're going to go with?
Yes.
You want to talk to your attorney before you stick with that story?
Yes, for real. I've been honest.
No, but do you want to talk to your attorney before that's the story you're giving me? Because this recommendation will change.
Mr. Ellington, I would advise you to accept what the recommendation is saying and ask the court to adopt that recommendation.
How about this cocaine, though? Because he's telling me
Yes.
that he didn't do it.
I would just ask the court to disregard Mr. Ellington's previous statement.
Well, I
Mr.
can't disregard it. That's like unringing a bell. I heard him.
Jim Simpson, I'm honest. I've been coming to court. I've been doing everything.
I know you're honest, but not an amoeba. You don't absorb things that way. So, counsel, I don't normally do this, but you want me to give you a breakout room to talk with him?
Yes, please.
And then we can talk about how the cocaine got there?
Oh my God.
Yes, please.
Yeah, I know.
Okay.
So time.
Joe Simpson, I'm being honest. My friend just
Sir,
passed away.
Mr. Ellington.
Sir, I don't doubt that part. I doubt the other part you just told me. Because, and I'm just going to lay it out there, you had a positive for methamphetamines on March 23rd. March 28th, you're positive, hold on, you're positive for cocaine. You go away, you do have a negative test in between then,
Jojo.
come back April 3rd, you're positive for cocaine again. So, and he didn't go to the CCOP program. So this may change in any event. Sir, I'm just going to ask you, do you want to go into a breakout room and discuss this with your attorney prior to the court proceeding forth with sentencing? Because I'm ready to go, but I don't know that you are.
Okay, Simpson.
So why don't we do this? Counsel, do you have Mr. Williams, is that yours? Yeah, I know. I see you, Mr. Williams. I just want to make sure. Q, do you have Mr. Williams or no?
No.
That's yours?
That's mine.
Oh, okay. I got you. So let's put Kasim and the amazing Mr. Ellington into a breakout room, and then we can bring them back momentarily.
Thank you, GP.
Right. Take care, guys. We'll see you in a bit. Here, this is also. Want me to go back to that one? Or you want me to
This
start?
was it. See, I told you I don't watch all the clips. I love watching it when you guys talk. You get my genuine
Court recalls the case. People versus Isaac
two.
Ellington.
This is Hump number 2, part
That's
2.
our Assistant Public Defender, Constable Basie, on behalf of Isaac Ellington. Mr. Ellington, could you unmute, please? State your name again.
Isaac Ellington.
Once again, Your Honor, we have reviewed the PSI, and Mr. Ellington does not have any.
Cocaine on it.
He would like the court to adopt the
It's on his
recommendation.
finger.
Mr. Ellington, would you like to go ahead?
Yes.
Okay, so what about the cocaine?
Simpson wants to know
I'll wait.
cocaine.
I was just helping my friend out. I did it once or twice, Your Honor.
You did what?
I did it once or twice, Your Honor.
So you actually ingested the cocaine?
Yes, Your Honor.
Yeah. That's a much better story than the first one you gave.
Yes, Simpson. John Boone, this one's for you, buddy. I didn't even know.
Sent to the court, 12 months probation, $655 fines and court costs, $360 probation oversight fees. When can you pay that?
I can pay $75 on April 21st. That's when I get paid.
You can pay what?
$75. On next week when I get paid.
He expressed to me that he would like to get on a payment plan if possible, Your Honor.
Yes.
Pay $75. Well, just a probation payment plan. Just. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You know what? No, he's going to continue on his testing.
Oh.
Yeah.
Honor, I will be clean. I swear, Honor. I swear.
Well, here's what we're going to do.
No more.
I hear you. So I'm going to give you a chance to prove yourself to me.
Okay.
Ms. Valera, I want him on testing, random testing through community corrections for the next 60 days. You're to complete the CCOP program or a comparable program. Now, when you do that testing, I'm just going to let you know. Any positives, you might as well just prepare for jail time. That's how I'm going to work this. I don't like people not telling me the truth, and you tried to start out not telling me the truth.
Okay, Honor.
You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2. Served. Defendant will serve an additional 5 days for the bond violations to date, and then the balance will be suspended.
Whoa! Are you kidding me, dude? Thank you so much, Sean Wexler. My man. Talk about new computer fun. That's a new computer right there, my friend. Thank you so much, Sean Wexler, for being here with me from day one, brother. Thank you so much. Let's roll, people. Wow.
Suspended. You are ordered to report to the Washington County Jail by 6 p.m. So I got 360 other reasons why you don't want to use. We clear?
Yes.
Thank you. Report to the jail by 6 p.m. or bench warrant will issue with no bond.
Your Honor. Okay.
What? What do you want to tell me?
I was gonna tell you, can I do it Friday. I could tell my job to hold my job and tell my kids I'm gonna be gone for 5 days.
You know what, Mr. Ellington, I would have been more than happy to do that. But the problem is you came to me lying to me.
What a dono, bro. Oh,
I don't know right now whether or not, hold on. I don't know whether or not you're telling me the truth right now.
I am telling the truth because I'm at my
So
job.
the problem, Mr. Ellington, is when you start out like that, I can't trust you. I can't trust you that you'll be there Friday. I can't even trust that you're going to be there tonight. But I can tell you, if you're not there tonight, what's going to end up happening, I'm going to send somebody out to get you.
Gave me chills, brother.
All right, I'm gonna be there Friday. I promise.
6 p.m. Thank you.
Your Honor, I would just like to say that Mr. Ellington has expressed to me how concerned he is about keeping his job, and since him keeping his job is part of PSI's recommendation, I mean, if we could just get a day, possibly, or two, and then have him report maybe by 6 p.m. tomorrow before the warrant goes out. Just to give him a small cushion to get his job straightened out.
No, not doing it. I told you what I'm doing.
Thank you,
He did what he did. Now I'm going to do what I'm going to do. That's just the way it works with me.
I will be there. I'm sorry.
And counsel, you know, if somebody had come to me and said, yeah, I accidentally used, or I shouldn't have used, I did this, then I'll deal with that. But if you come to me just straight up lying, and I'm telling you, I don't believe your story, and you continue to lie, and then I got to put you into a breakout room with your attorney, and now you're going to come back and tell me the truth? Really?
I'm not.
And now you want me to do something for you? Don't think so. I'm done.
I'm not lying.
He's
I'm done.
2 and 3. Bravo, Simpson. Let's roll, people. Okay, so now this is coming from Mark Baggett. He's a YouTube channel. He's got about 10,000 subscribers. I've been following him for a little while. He does sob sits, Karens in court, DUIs, everything. He's got a great channel. He's humble. He's cool. Don't think he does a lot of live streams. He kind of just uploads short, sweet, to the point. The dude's cool. So I'm taking a video from him because we voted on Karens. So this one is ridiculously good. Sit back and enjoy this. Wow. You voted on it. This is what you get, people. And it is stupendous.
Hey everyone, it's Mark, and a few nights ago I was going through my video archive and I found a Karen in court video. Now I don't know the context behind this court hearing, but this Karen's behavior is really something that you have to see. Let's roll the video.
Good morning. How are y'all?
Morning, how are you?
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir. Get us off of your docket is what you could do.
You can tell she has a great attitude. This hearing should be interesting.
Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes, sir. Specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Thank you, Mark. You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrew, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me, or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions, and then we ultimately never got a response, and she filed a motion for protection.
She got plenty of responses. Objection.
You just can't yell out whenever you feel like it, Karen. Even though this hearing is on Zoom, you're still in court, so act like it.
What's your objection? Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She
to
also represents Cody and all fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So Ms. Kimball, why don't you just go ahead and finish telling me what, so you said that you're wanting a drug screen, so drug test, and do you say psychological or psychiatric? I thought you said
a psychological exam. And then we have a order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition, and for attorney's fees for $1,500.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll file for marijuana.
When was the last
But
time?
I'm happy to take it on.
When was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
Wow.
Hump
number
I'm
3.
allowed to take the drug
Stop,
test.
stop, stop.
Okay, go. It's going to be on his expense,
Stop.
but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
Your Honor, I don't think she knows what the word respectful means.
So you can just, if you're going to use my last name, that's fine. Just say Judge Tenig. Okay, it's pretty easy. So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenig.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your position.
That's my response to you. Okay. You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera.
This is where it really starts to get interesting. This Karen only makes things worse for herself.
Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates. What's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I can. I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee. Woo
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Instead of fining her, I think this judge should issue a warrant for contempt. Her behavior is unacceptable and it's disturbing the court proceedings.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're gonna want.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
what
then
date are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What are you
I
anticipating?
would anticipate a full day.
Okay.
So what? The
Ms.
30th or the 2nd?
Yep. Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempts.
You're correct. That is 3.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
Yes.
What date?
Stiles, that question is to you. Never
I
mind.
said what
I'm not gonna-
time?
I'm not gonna let you
Time,
pick.
date. You know these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation. So, in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record that she opted out after flipping me off.
Judge Ten Ike.
I won't comment. So I'm going to grant the
comment.
request for August the 30th at 9 a.m. in your office.
Honestly, her leaving the Zoom meeting could have been the best thing she did. And like I said before, if I was this judge, I would issue her a warrant for contempt of court. An alternative title to this video could have been How Not to Act in Court 101. As always, I would like to give it.
All right, that was my man Mark Baggett. All right, he's got a great little channel. He posts not every day, but he posts good ones. He's got good clips. All right, here we go. Let's rock and roll. We've made this court has been on this show before. I got away from it a little for some reason. I don't know why, because it is absolute gold every time it's on. And this is Albany, Georgia. And this is Judge Weaver. And his voice and projection and just his demeanor and his court etiquette is tops. And he had 2 great defendants. Let's rock and roll. This is Judge Weaver. If you guys want to look this up, this is Albany Municipal Court. It's Albany, Georgia. And they stream and keep the streams up so you can watch past stuff. And they're on from 7 to 9 every morning. So here we go.
Yeah. Judge, Ms. Wolf, back to Canada.
Good morning, Ms. Woods. How you
Thank
doing?
you. All right.
All right, let's play a game. How old do we think this defendant is? Ready, go.
Ms. Woods, you are 60 years of age?
Yes,
Answer,
He's
Judge.
gonna ask you the question.
no, sir.
How much education do you have? How far did you go to
60,
school?
good lord.
all the way through high school.
You have a right to a
I didn't
trial.
graduate.
presumption of
Hump number.
witnesses,
I didn't graduate. I took my GED.
and the right to remain silent and not incriminate yourself. Do you understand your right?
Yes, sir.
You're charged with disorderly conduct for beating on the door at 110 North Washington Street
90.
and claim you disturbing employees and customers at the location.
Sir,
What kind of place?
Beating on the door.
So you beat
I didn't beat on any door, sir.
What kind of place, bro?
He apprehended me west side
Where do you live, Miss Wood?
with my son. I was waiting on my son to pick me up. I'm waiting on my son to pick me up.
Mr. Lepper, how does she plead to the charge?
How do you want to plead? Not guilty, guilty, or
Not guilty.
no?
Not guilty, sir.
No contenders is a good option too.
No.
She gonna plead not guilty.
I don't know what the charges. I don't know what the charges were supposedly. I never heard anybody.
Disorderly conduct.
Do what?
Disorderly conduct is a charge.
No, sir.
Late 30s.
I haven't disorderly
Mr. Lepper,
conduct.
Yes,
Mr. Lepper was alleged that you had Fit Nation at
What
110
any
North
disorderly
Washington.
conduct, sir? I was walking along and I was apprehended.
sorry, Your Honor, we didn't hear you.
Well, ask her to be quiet while I'm talking. Miss Wood, will you be quiet for a second?
Yes,
Don't say
sir.
anything.
Yes,
The
sir.
allegation is that Miss Wood was beating on the door and yelling at Fit Nation, 110 North Jackson, and she was disturbing the employees and the customers who were apparently trying to work out.
No,
Those
sir.
are the
That's
allegations
true. I wasn't even there.
Be quiet, Miss Wood.
Yes, sir.
Those are they're to being charged with disorderly conduct.
Oh, I apologize. No, sir.
You interfere him again, you gonna stay here.
Okay, I'll be quiet.
Now, Mr. Lester was talking to you about how do you want to play. You heard the allegation that you was beating on the doors at the business. You want to enter a not guilty plea and stay in jail till your trial? You want to enter a no contest plea and go home?
No contest, sir.
Excuse me?
No contest.
Go ahead and speak into the microphone.
No contest, sir.
Oh. Austin Kenfo, Helen Hawkins. No continue plea to disorderly conduct. She to stay away from Fit Nation.
Yes, sir.
Sign here.
Sign here.
Sign your name.
She'll be sentenced to 3 days in jail with credit for time served.
Sir?
Time served.
Excuse me.
She'll be sentenced to credit for time served.
Sign your name.
Yes, yes, sir.
Sign it and shut up. If you watch this stream too, if you watch this stream repeatedly, he has like people that whisper and like thugs. He's like the Louis Farrakhan of court. Like I call him Judge Farrakhan, because he has like these bailiff type like guys that like surround the defendants and like even the people that come into court, and like if they don't do something that they agree with, they huddle up real quick on them and go and then the defendant's like, yeah, okay, I'll plead, and then they back up. You'll see it. They just did it. And if you watch this religiously, you will see it. So I call him Judge Farrakhan. Thank you, Jojo member.
Sure will, man.
Where in recess do we meet downtown?
All right, sir. Thank you. Your Honor.
Okay, so now that was yesterday, and now today she's back. So I don't know if she stayed the night, because he said I'm going to give you credit for time served, and she leaves. apparently. So now this morning I'm on and I hear "sir" in the background while I'm working, and I'm like, no, sir isn't back. So here we go. So she's hump 4 and 5.
And the abstention.
Yeah, we got Hawk and Cook, Baker County game.
Do you have copies of these?
No way, Hector.
I just have it.
All right.
Have a seat, Ms. Woods.
Yes.
Good morning.
Benny.
Speak
How's that, Mike?
clearly where the judge can hear you.
Repeat that again, Emily, I didn't get it.
The order for Ms. McClendon is
Oh,
on
this son never picked her up.
4652.
You Miss Woods?
Yes, sir.
You're 60 years of age?
He just asked her that yesterday.
How much education do you have?
I'm going on 60, sir.
He asked her all this yesterday.
Ma'am?
I'm 59 going on 60.
You were wrong with 60 people.
11/29/62.
11/29.
1962.
All right, how much education do you have?
Pardon?
How far did you go in school?
I went to two high schools, San Clemente High in California, Doherty High here in Albany. I've been here in Albany since I was 16 years old, sir. I went all the way through school, took my GED when I turned 27, sir.
Where do you work, ma'am?
I don't have a job. But I stay
Are you mentally disabled or under the influence of alcohol, drugs, or medication?
in the house. In the house. Sir?
Mr. Let's go over her rights with her and then let me know if you believe she understands her rights.
Sir, we went, Ms. Woods, we went over your rights last night. She did a plea and waiver of rights and abstention. And then we also have the advice and waiver of rights that she signed last night. And I read you your rights. Remember, you had the right to trial by jury, to be presumed innocent of all charges, to confront witnesses against you, and examine them in court, to subpoena witnesses and have them come and appear in court on your behalf, the right not to incriminate yourself, and the right to be represented by an attorney. And if one cannot, one may be appointed to represent you, and I have been appointed to represent you. There's no charge to you. You understand? I told you that last night, right? You remember?
Yes, sir.
Okay.
He's hitting on her. Look, he likes her. He's a little young for him, though.
She entered a nolo contender to the charges, Your Honor.
All right. Are you satisfied, Mr. Lefford, that you understand her right?
Yes, sir. I'm satisfied. She well understands her rights.
All right, the court accepts the nolo contingent plea to lottery. Court sentences her to 4 days in jail with credit for time served. And she is to stay away from Waffle House at 121 West Overthorpe. West. Oh, is that right?
Wait. All right. So last night she definitely got picked up again because it was the fitness club yesterday, and now today he just said stay away from the Waffle House. So she was messing around with people at the Waffle House. How do you get locked up from a Waffle House? Oh my God! You, sir, stay away from the Waffle House, sir.
Stay away from that Waffle House. You understand me, Wood?
Yes, sir.
You understand to stay away from Waffle House?
Yes, sir.
She liked it.
All right. If that concludes our business, we're in recess until we meet downtown.
Stay out of the Waffle House. Replay.
Stay away from that Waffle House. You understand me, Wood?
Yes, sir.
You understand to stay away from Waffle House?
Yes, sir.
All right. That concludes our business. We're in recess until we meet downtown.
Thank you. Thank you, sir.
I'm sorry. That wasn't as funny
Oh, wow.
before. There it is, the Farrakhan people. Look, they all huddle. Get her. Okay, so here we go. So now this was a couple defendants later. And just listen to this guy's story. Sean Wexler, you stallion! Oh my God, grab your memberships, people. He's lurking. He's hanging out. Where is he? And then boom! Numero uno. Time served, Army. Boom! My man. Stay at that Waffle House. Sean. Okay, so now just listen to this guy's story. Oh, God.
Mr. Wallace, you are 44 years of age?
Yes,
44.
How much education do you have?
9th grade.
Do you have a GED?
No, I went back to school in New York, but pretty much I went to school all up and down the East Coast.
Traveler.
Do you have a job?
No, I'm just getting into town.
Are you mentally disabled or under the influence of alcohol, drugs, or medication?
Definitely.
Not at all.
You have the right to a trial, the presumption of innocence, the right to confront and subpoena witnesses, and the right to remain silent and not incriminate yourself. Do you understand those rights?
Yes, sir.
Understanding those rights, do you wish to waive your right to a trial and enter a plea to the charge of disorderly conduct?
Yeah, I pleaded no contest, Judge.
You have a record without point.
Down here, that jail.
Yeah, we might.
Yeah, that'd be.
All right, the court accept the normal contingent plea to disorderly conduct. I sentence you to 2 days in jail with credit for time served. You ought to stay away from Dollar General at 300 East Oglethorpe. Do you understand?
Yes, sir.
Do you live close to that store?
Here we go.
I actually do, but not that particular store. I'm glad you allowed me to speak, Judge. If I may say something, I purchased my items from a Dollar General on the other side of town, and I was out that day trying to do my taxes, and I was also trying to wash clothes. So it's unfortunate I end up in jail, because the clerk or something like that. Would you call them? The customer service. They did not. They didn't accommodate my receipt. So I bought 2 items. I bought some fragrance-free washing powder, and I bought some sanitizer to go with it. It's like a Lysol sanitizer that you can wash with your clothes, right? But the sanitizer, it had fragrance in it. It was called Crisp Linen, right? That's the name of the fragrance. And so basically, I just wanted to take it back. So they didn't have any, they didn't have a product that didn't have fragrance in it. So the only reason why I took it back was because the lady was being so disrespectful. I went to the store and she was basically trying to be my mama. You understand what I mean?
agree with you that customer service is at an all-time low, but we still can't get mad and cuss them out.
He just said the customer service is at an all-time low, but that's no excuse for being a jerk. Judge Weaver doesn't like customer service in 2023.
And show out in the store.
Yeah,
I
apologize
because
for that.
customer service is not good, but we have to handle our side of it too. They probably had poor customer service, but the allegation against you that you got upset apparently and cuffed it. Work out that we're doing poor customer service, so we can't have that. So don't go back to that store. Go to another
What
store.
about my money, Judge? About the washing powder? I don't have a receipt now. It's almost like they robbed me.
He said that they Dollar General robbed him. I can't. Oh God! Look at him looking at the judge. They robbed me.
I don't mean to put it that way either, but I'm just saying though.
I've heard what you had to say.
Yeah.
2 days in jail clear for time served. You can go.
Yeah, thank you. Enjoy the rest of your day.
Bravo, Albany, Georgia. Stay out of the Waffle House. Stay out of Fulton County. Stay out of the Dollar General. Gonna get robbed by the disrespectful clerk to try to be my mama. And then Weaver said, I know customer service is at an all-time low. Come on. You can't make this up, people. All right, here we go. Let's go to Judge Stepdad from Amarillo, Judge Henderson. We love Judge Stepdad. He has nice things in his pocket for us. He's wholesome. He drives this older model Saturn. He just wants to be your pal, and he'll drive you to practice because your dad doesn't show up. And that's when Judge Henderson comes for you.
Sorry, I kind of got your paperwork out of order here, so I was trying to get it back
Thank you, Allison.
in after I messed it up.
Yes, sir.
So, okay, I think I got it. All right, so let's talk for a second about the ones that not pled to. On April 7th, you got a driving with an invalid license and a no insurance.
Hey, Toby.
On March 22nd, you got fail to control speed, no insurance, and driving with an invalid license. And on April 11th, you got no insurance, invalid license, and wrong license plate. I'm just saying, for somebody who doesn't have a car and can't go do community service, you drive a lot, it does seem like. What are you wanting to do on these new violations?
The April 11th. Which I was
can't
just
hear you.
yesterday.
It's
Oh,
you're
sorry,
cutting
sorry.
out.
Just payment arrangement. If I try payment arrangements next month on everything, I'll.
How do you want to plead? How do you want to plead on all these? How many tickets did you say you have?
Guilty.
What?
You plead guilty on all these?
Yes.
What's up, Denny? I see you.
Okay, I'm gonna accept your pleas of guilty. Clause number ending in 392. Driving with a license invalid. That's 384. And no insurance. Stop talking. Or mute yourself. One or the other. 315. Let's see. 027. No insurance. You know, you're never gonna get yourself out of this hole if you keep driving, you don't have insurance, and you have an invalid license. Those are expensive.
Yes, sir. I don't know why. All I gotta do is go down and take the test to get my license. I've never taken it in Texas, so I'm.
Well, that would solve some of your problems.
Is time served his sound guy?
Yes, sir.
Display a wrong place.
I thought you don't know if I could pass it.
And March 23rd. Okay.
Yeah.
shut up. What is he
These
doing?
no insurance tickets, whew, they add up every time. I mean, this one by itself is $683.
Ooh.
So you set up a payment plan, but then you get more tickets, and it just keeps piling up on you. You're not making even when you're paying a little bit, it hardly is making a dent. Okay, so how much are they going to pay you over there?
I think it's $17 an hour. I think 16, 17 somewhere in there.
Here comes our little
Okay.
Gilliam.
Can you pay $100
Here's Gilliam.
every couple of weeks, or $75 every couple of weeks?
Can we start at 75? And if I can pay extra, I will.
Okay.
Here's Malachi.
So I'm going to start that on the 15th, okay?
Of next month?
Yep.
Okay.
Poor Malachi has ADD. He would be in my class, guys. He really would. This is my population.
9 tickets.
You guys asked. I know a lot of you guys asked.
How many tickets did you say you have?
Malachi's my guy.
9, I think. Is that what it come? That's how many you counted?
I haven't counted. That's why I was wondering what you thought.
Jesus.
Is it 9? 10?
I haven't had that many tickets in my whole life.
10 tickets. So here's the thing: is if you can't pay, you got to come back, because that would, if you let these go to warrant, that's going to tack on $500 just in warrant alone. So always come back if you're having payment issues, to let us know so that they don't go to warrant. Okay.
Yes, sir.
Because that'd be unfortunate if you had paid $500 and then you let them go to warrant, and it just wipes out the $500 that you had paid.
Congrats, Les.
God.
And you just go talk to them there. They won't let you go.
We're going to send you some new paperwork, or some paperwork for this new payment plan. Do you want us to mail it or email it? We need you to sign it and get it back to us. So what's easier for you?
Mail it.
Mail it.
Or if you could do both, that'd be great.
Okay.
That way I'm sure to get it.
Bring it up there and look.
Can I bring it up there, or do I need to mail it, or how do I get it back to you?
Yeah, you can bring it up and drop it off.
Okay.
Hang on just a second. Let me just finish. So.
This guy's got 10 tickets. Hump number 6.
Okay, I got it all. We're going to send you the new paperwork. You're going to sign it, bring it to us. That's going to set you paying $75 every other week, but it's not going to start until the 15th. So hopefully that'll work out for you. But if not, make sure you come back, okay?
Yes, sir.
Thank you, Mr. Stevens.
Thank you.
Okay.
He's 15,
Let
guys.
me look here.
This guy's 15. So now we're going to
Okay,
hear from
Mr.
him.
Knoll.
Look at this poor guy. He's been here for hours.
So Mr. Gillen is going to ask for another appearance date in 45 days. I did talk to him about juvenile deferred and what that would look like, and he needs some time. And if we could give him 45 days, he'd like to come back and see me before then.
Okay. Mr. Gilliam, I've got to give you additional juvenile warnings. Here, just make sure I give it to you right.
Oh no, it's a big binder.
Yeah, it is a big binder. I've got to read this whole thing to you. Okay, it says, really, it's just a little paragraph. Both you and your parent have a continuing obligation to notify the court of any change in address. That obligation does not end when you turn 17, but only upon the final disposition of the case. In addition, you have an obligation to resolve the case by the time you turn 17. The failure to do those things, either not update your address or not resolve the charges and fail to return, may result in a separate charge being filed after you turn 17, and a warrant may be issued on that charge. And you may have certain rights to have a juvenile conviction expunged after you become an adult. Giving you that, it looks like your mom, Melissa, is there. Is that correct?
Yes, sir.
Okay. We're going to enter a plea of not guilty. We're going to set you for the virtual docket about 45 days out, right?
Yes, sir.
And we're going to send you that new date. Do you want us to mail it or email it to you?
Email, please.
Okay. So be looking for that. If you don't see it in your email or the junk or spam folders, probably by the end of the week, be sure to call and let us know so you can get that date and not miss it, okay? You have any questions for me, Malachi or Melissa?
Well, I asked her, but I talked to an officer about, and he said call the number on the ticket about getting your driver's license. But I don't know how that would work.
I'm not sure. I'm not sure what the question is. I'm not sure what it's referring to.
I told him he had to contact DPS about his driver's license.
Yeah.
Did you have it? I don't know. How old are you? How old are you?
15. But I turned 16 in like 3 weeks.
Oh, okay. All right. So your question is,
am I allowed to still get my driver's license?
Oh, about not messing up getting your driver's license. Oh,
yes.
Well, I mean, right now, I guess you aren't because you haven't pled to anything. But
okay.
I don't know, Miss Denholm, how getting
from talking to other people through the years, they've gone ahead and gotten their license in the same process that they're keeping this off their record. Is that he hasn't pled to it yet, go get his license, and then do the deferred and keep it off his record.
Yeah.
Okay.
That sounds like probably the best plan for, I mean, if that's what you're trying to do. Or maybe the best plan is you plead not guilty and have a trial. I don't mean to suggest what the best course of action is for you, but keeping it off your record, deferred would do that if you're interested in that.
Okay.
So we'll send you that notice, okay? So make sure you get it.
Yes, sir.
Okay, thank y'all. Have a good evening.
No problem.
You too, thank
you. You too, bye.
Okay. All right. So here we go. We are going to go to... Okay, so right now I'm going to show us a absolute gem. I'm pulling from my boy Mark Baggett again. He has an old school Sov Sit fail video from, I think, 2009, before Zoom Corporating, but it is a recorded court proceeding. The sound is great. The guy's a fool. He's hump number 7. Thank you, Mark Baggett. If you haven't subscribed to his channel, check it out. Here we go.
Misunderstand the procedure. I will attempt
video.
As a
it is not my obligation, and do not point to
Yes,
me.
you have a constitutional oath to uphold the Constitution, ma'am.
You misunderstand the procedure. I will attempt to explain it to you.
Objection.
The documents that you want are not documents that are in the court's file at this point in time.
Objection,
I don't know
ma'am.
if they would ever be in the court's file at this point in time.
That's not my problem, ma'am.
If you absolutely, it's your problem.
But that's
your
not my
position
problem.
is that you want them from the prosecutor, and you have requested them from the prosecutor.
That's right.
And the prosecutor has failed to give them to you.
That's right.
You can make the appropriate application to the court, and you can say to the court, I've asked for them, I'm entitled to them, I haven't gotten them, order them to give it to me.
I've already
I have
filed
received
a
no such-
notarized affidavit of fact in reference to return of property weeks ago. A notarized affidavit. So if you're telling me you don't have to acknowledged affidavits, all right, that's what your statement is. However, bottom line is this court has failed to prove jurisdiction and has avoided the issue of jurisdiction at all costs. And you don't, nobody in here has the status.
It's clear to me that you think the court has jurisdiction, otherwise you would have never shown up for court.
All right, nobody has proven status, and nobody in here has the authority to proceed. Now, the last hearing we discussed, you stated that
Could you please stop yelling at me?
this matter, you stated, ma'am, for the record, you stated that this matter was relative to jurisdiction, not Mr. Keesler's position here and not anything else. You stated that you were giving the prosecution a chance to prove jurisdiction, and he's not even the assigned prosecutor to the case, but obviously he's remaining silent, and he has nothing to state. So I move that this case be dismissed.
When there is an appropriate application before this court to address the issue of discovery violations, jurisdiction, or anything else, the court will act. Filing a notarized or not notarized affidavit is not an appropriate way to bring a matter before the attention of the court. What you must file is a notice of motion that sets forth the relief that you want, and it needs to be supported with a certification, an affidavit, whatever it is.
Can you repeat that, ma'am?
Notice of motion. This is
And that-
exactly what I told Cheyenne Matoda Kushner L.
For the record, man, which rule, authority, courtroom rule, statute are you using
It's in the court rules. I do not
address that
recall.
matter?
It is in the court rules. I do not recall, and I'm not going to look up for you the exact court rule, but the court rules set out the procedure that you must follow.
Objection, ma'am. I'm not a party to society. I'm not subject to your courtroom rules, and you have not proven jurisdiction.
I think the judge should prove jurisdiction to him by holding him in contempt of court.
And I will never address the issue of jurisdiction until and unless the appropriate application is made before the court, because filing either an affidavit that's notarized or an affidavit that's not notarized does not bring it before the attention of this court.
Objection. There is no discretion to ignore the lack of jurisdiction. Joyce versus United States. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction in here is void ab initio. And that is application of Y300 P.132 versus Caveat. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Melo versus United States 505 F2D. When jurisdiction is challenged, the party involved jurisdiction has the burden of establishing. Basso versus U.S. Power Light Company. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not attain jurisdiction by service of process, nor even arrest and compelled appearance. I'm here by way of threat, duress, coercion. I'm going to make that clear for the record every time I have to appear, if I have to appear. The only reason I'm appearing here is by way of your threat, duress, coercion, or your company's threat, duress, coercion.
You can
Once
read
jurisdiction
me,
is challenged.
let me interrupt you, please. You can
Okay.
read me this until the cows come home. You can read it ad nauseum and ad infinitum. It doesn't change the fact that until the issue is brought appropriately before this court, no ruling with regard to jurisdiction is ever going to be made. Now, let me ask you this question, though. In the other matter, first of all, let me backtrack a little bit. Let me get the correct number out here because we now have two numbers. In the case with indictment number 08-04-0441, which is the one in which Cheyenne M. Cushing-Murrell is also involved, I have severed those matters, so they will be on completely separate tracks. But he told me that he had filed a notice of removal to the federal court. And my question to you is, have you filed a notice of removal to federal court with regard to any of these matters?
Yes, ma'am. Notice of removal
All
has
of
been
them?
filed
All of them?
regarding all matters.
The three matters?
Yes, the three matters that you.
May I ask you, please, would you tell me,
referenced.
when did you file this?
It was filed last night. FedEx.
To
By
the
way of
federal
FedEx,
court?
to the federal court.
All right.
Yes.
Well, as I am sure you are aware, if the court accepts them, then we will simply transfer them to the federal court. We won't deal with them anymore.
Okay, well, I'm still sure you're aware of the matter that you've not proven jurisdiction in either of the hearings and that you've avoided addressing the issue of jurisdiction.
He's like a broken record. He keeps arguing the same thing over and over again. Take the hints opposite. The judge isn't going to dismiss the case for lack of jurisdiction.
And I will continue to not address the issue of jurisdiction until the appropriate motion is filed with the court and the court has the ability to address it and make a determination with regard to it.
And Judge, if I could just for a moment, that's the issue at hand. As currently stands, we are representing.
Objection. You're not representing me.
Therefore, it would be our responsibility to file that motion. Given the fact that he will not cooperate with our office, it's impossible for us to do that.
Objection.
We really need to reach the issue.
I want to get back to what I do want to get back to what Amir KCL said. Now, we addressed the issue to some extent with regard to the indictments. I have here for you, and the record will reflect, that I am giving you a copy of the indictment that has 08-07-0727 and also 08-04-0441.
Objection. Just for the record, the Office of Public Defense is not representing me. You don't have any power of attorney for me, and I'm not part of your society, so you cannot represent me, and we do not share nationalities.
I feel bad for this lawyer who has to deal with his sovereign citizen nonsense. Also, what does sharing nationalities have to do with anything? That's completely irrelevant in my opinion.
Okay, now, for the record,
Mr.
I need the
Kramer.
nationality of every agent in here, and I need the name and the information, because I'm suing everybody.
Well, good luck with that.
How exactly do you plan on suing everybody when you stated multiple times that you aren't part of society and you think our courts have no jurisdiction? Do you plan on suing them in your make-believe court that has no authority whatsoever?
Mr. Kramer.
Everybody. So I need everybody's name and your position, starting with you, sir.
Who is calling out from the audience?
I was, ma'am.
No, you were not.
Who
was? No, do not hand anything over. Nothing. In the audience, please do not call out while court is in session, or the officer will ask you to leave.
This is great. This is great.
These are now completely discombobulated. They're not stable to. Well,
the one wasn't stable. The one was.
And ammonium.
no, I don't have. Look, you can't even read this. Is that what I gave you?
I think so, yes.
Right.
I give you back the original. The copies. I gave them to her. Okay.
I need your name and position, sir. I need your name and position, sir.
No one is going to give you any information.
Ma'am, are you stating that you are not obligated to provide me with your identity and status?
You know my name.
Your employees or your co-workers are not obligated to provide me with their identity, status, and company position, ma'am?
You know my name.
Ma'am?
Yes?
Did you not just hear me?
I didn't hear you. I'm sorry. I was trying to get the paperwork together.
Okay.
Can you wait a moment till I'm finished?
No, I'm going to repeat myself. I'm here on the time, ma'am.
Now, hold on. I'm trying to get all these papers together.
Oh, it's a simple question. I'm sure you can answer it while you get your papers together.
I cannot get them together. I can't answer. This only has 3.
He's got to give his uncle his suit back. Could we get a suit a little bigger, dude? Just a tad bigger? Good lord.
Okay. This has 3 counts, and this you didn't make a copy of the last count. So make a copy of the last page and bring it in, and we'll staple them together. Noble Amir KCL. You complained about discovery. I think I've addressed that. I'm giving you the copies of the indictments, and you said you've never been interviewed. I am sure that Mr. Kiesler can give you now a date for you to be interviewed.
Objection, ma'am. I do not require the Office of Public Defense or any attorney at law.
Well, you told me that you were complaining that you hadn't been interviewed.
No, what I stated was, if he was representation on this case, he has not provided assistance. If he was representation for this case, the assistance is ineffective.
Well, my understanding is that Judge Smith has required Mr. Kiesler to represent you.
Objection. I've addressed this matter with Judge Smith. Judge Smith does not have jurisdiction and could not prove jurisdiction.
The words of the day must be objection and jurisdiction. Like, seriously, I have no idea how any judge could listen to this nonsense for this long.
Therefore, Judge Smith does not have the authority to make any decisions for me. And neither do you. And neither does Mr. Kiesler, and neither does the Office of Public Defense. For the record. Now, as I stated, you just told me that you did not hear my question. My question was, I need the information for the people here who are attempting to force business on me. I want his name and position, I want her name and position, and I want his name and position. And I want your nationality.
Not to point at me, and I am now going to ask you not to point at anyone else in the courtroom. It is very impolite.
No problem, ma'am. Now I'm asking you to answer my question.
You know my name. That is all you need to know.
I don't know your name, ma'am.
Judge Laban. That is my name.
Your nationality?
You have no need to know my nationality.
Yes, I do. You are attempting to force business upon me. I need to know your nationality. For the record. And your status. For the record. And anybody else that's working with you.
Your questions are unintelligible to me.
They're unintelligible? Do you not understand what nationality means, ma'am? Do I need to pull out the dictionary? Which dictionary are you comfortable with using, ma'am? For the record.
All right. The record should reflect that I am going to give to Noble Amir Kusamir L. I'm sorry, Noble Amir KCL, a copy of indictment 08-07-0727 and indictment 08-04-0441.
Objection, ma'am. Could you state for the record who those indictments are addressed to?
Well,
stating who you were giving to. Objection. Wait, no. Hand that back to her because she needs to repeat. She needs to state for the record.
I am handing the papers to Noble Amir KCL.
I need to know who's on it, ma'am.
It doesn't matter who's on it.
Yes,
I'm
it
giving
does.
you copies of papers.
I need to know who's addressed to.
Read it.
If it's not addressed to me,
read it.
You've not read my notarized affidavits.
Read it.
You've not read my notarized affidavits.
Well, this is what I'm going to do. I'm going to give this matter another date. Mr. Kiesler, you can make whatever application you want. Noble Amir KCL, you can make whatever application you want. Hopefully, in the meantime, we will hear from the federal court with regard to the removal application.
I'm going to just state for the record that your application to do any further proceedings are denied because you have not proven jurisdiction, neither has the prosecution who was here and present. Prosecution, would you state your proof of claim for the record?
Your Honor, would any motion by our office be heard on the next date, or would you set a separate hearing?
No, it will be heard on the next date.
Thank you.
For the record, the application to proceed to set any hearings is denied. It's not proven jurisdiction.
I'm starting to think that this is the guy that taught Darrell Brooks everything he knows about
subject matter jurisdiction.
April 6th.
Denied.
Thank you, ma'am. May I be excused, Judge?
This is the only notice that I will give Noble Amir KCL at the April 6th date. I don't know if anyone sends out, I don't know if Mr. Kiesler's office sends out letters reminding people, but I don't. I simply expect that you will be here on April 6th. And please, let me just say this. If you want this court to rule with regard to jurisdiction, it is very simple to bring the issue before me. All you need to do is file the appropriate application, a notice of motion.
Objection, ma'am.
You can file all these other papers, and it's just never going to happen, sir.
Objection, ma'am. That's not my problem that you're not upholding the law, ma'am. That's not my problem. That's your problem, ma'am. Because whether you people understand or not, you've all fired yourselves. So there is no room to set another hearing because you failed to prove jurisdiction in every hearing that we've had. Judge Smith has failed to prove jurisdiction. You failed to prove jurisdiction. Prosecutor Luciano's failed to prove jurisdiction. You people fired yourself. I'm letting you know that right now you violated your constitutional oath. I'm protected by the Treaty of Peace and Friendship via 1787.
Have you excused her?
Yes, Mr. Kuesler, thank you.
Is this matter dissolved?
No, it's not dissolved.
This case happened.
Bravo, Mr. Baggett. 300 in the room, and just for you, we're going to end it with Judge Webster and a Karen in her court today. She's calm, but what she did to get to court, tisk, tisk, tisk. Hump number 8. I told you there was going to be female humps. Let's roll. Guys, I appreciate everything. You guys are the best. This is the best chat. I swear. Thank you, Miss Sumler. I love you too, darling. Thanks for watching. Here we go, people. Let's get some Judge Webster up in here. Told you Mr. Baggett has some quality.
Is Jocelyn M. Whitmore.
Oh boy.
If the defendant would please start your video. And Ms. Whitmore, you are set for trial. Do you still wish to have your bench trial?
Yeah, sure.
All right. Mr. Regier, are you ready?
I am, Your Honor.
Any opening statements from either party?
Your Honor, the state would waive opening argument at this time.
Ms. Whitmore, any opening statement?
What do you mean by opening statement? This is my first time doing
Okay,
it.
if you don't know what it is, you probably don't have one.
Okay, then no.
It's your statement. It's your statement of what your evidence is going to show.
Hump.
Okay.
You have one?
No.
Okay. Then, Mr. Regier, please call your first witness.
Your Honor, the state calls Deputy Thomas Maloney to the stand.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please proceed, Mr. Regier.
Thank you, Your Honor. Please state your name for the record.
Deputy Thomas Maloney,
Where are you employed?
Butler County Sheriff's Office,
What is your professional title?
Deputy.
How long have you worked as an officer?
3 years, 3 months.
And were you on active duty in your professional capacity on October 25th, 2022 at approximately 5:40 a.m.?
Yes, I was.
Okay, on that date and time, where were you at?
I was located on Andover Road, just between Southwest 120th and Southwest 130th.
And is that in Butler County?
It is.
Were you in a vehicle or on foot?
I was in my patrol car.
Were you moving at the time?
I was not.
And what direction were you facing?
I was parked on the east side of Andover Road facing north.
Okay, could you please paint a picture of your surroundings for the court?
Well, it was dark out. It was pre-dawn, so it was dark. There's not a lot to see there. It's a hardball road with a medium in the center, soft shoulders on the side. I was parked on the east side off of the roadway on the shoulder with my lights off, running stationary radar. Light traffic, grass on both sides for the most part. That's more or less a non-residential area.
Now you say it was a non-residential area. Are there any buildings nearby in this area?
No, just fields to the east and south.
Okay. So with that in mind, would you describe this as a pretty open area then?
Yes.
And I think you talked some about the road with it being a divided road with shoulders on both sides. Is this a paved road?
It is.
And you already mentioned that it was dark outside. No, that I'm assuming this was because of the time of the stop.
That's correct.
What was the weather like at the time?
Temperature wise, I would say it was probably between 25 and 40 degrees. It was nighttime, so it cooled off. I can't tell you if there was clear or if there was any clouds.
Okay. Are you familiar with KSA 8-1558?
I am. That is the code for speed, maximum speed limits.
Okay. And what does what does that statute say about drivers and maximum speed limits?
Are you asking for the definition for the verbatim out of the KSA book, or do you want what are you asking for, I guess?
In your own words, what does the statute say that drivers are supposed to do as far as the maximum speed limits are concerned?
No driver shall operate at speed in excess of the maximum speed limit.
Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8-1558.
Court shall so do.
Do you consider yourself capable of identifying traffic violations when you see them?
I do.
Do you have any past experiences or special training which allows you to identify traffic violations?
Yes. For every day that I work, I run stationary and moving radar. I went to class to be trained on using the Stalker radar system and certified.
And so you are certified to use this device that you've already talked about, Stalker radar?
That is correct.
And you also mentioned certification. How often does that certification occur?
At this point in time, I couldn't give you an exact date.
But it is recurring?
It is, and it's required by the sheriff's office.
All right. At the time that we've already talked about, October 25th, 2022 at 5:40 a.m., did you see any acts that you considered traffic violations?
I did. The defendant was driving over the posted speed limit.
Okay. So you saw a vehicle traveling over the posted speed limit.
That's correct.
Now, how could you have seen the vehicle if it was 5:40 a.m. in the morning?
So obviously the vehicle the defendant had headlights on the vehicle. When the vehicle approached me from the rear, I have my rear stationary radar on. I get an audible tone, obviously, and then it indicates the speed on the radar box itself, but I can see the headlights behind me and her being the only vehicle coming down the roadway. To me, it was obvious that she was traveling at that posted speed on my radar.
And did you yourself have your headlights on at the time?
I did not.
Did you turn your headlights on?
After the defendant passed by me, I watched her speed reduce as it came near me when I believe she saw my patrol vehicle. As it passed, once she passed my position, I turned my headlights on and I conducted a traffic stop with her.
Okay, so after the vehicle passed you, you turned your headlights on.
That is correct, and then merged into the roadway appropriately.
Okay. So when all this has happened, once you had merged into the roadway, you were behind the vehicle facing it.
That is correct.
And how many other vehicles did you say were on the road besides yourself and the vehicle that you saw speeding?
I can't confirm how many were on the roadway but in my immediate proximity, she was the only vehicle I saw coming from my rear and passing me before I pulled out.
Thanks, Bear.
Can you please describe the vehicle that you saw? Make, model, color?
So the vehicle was a silver in color Nissan Murano. I can't tell you the year right now. I believe it was a 2010, 2011.
Okay. And what direction was the Nissan traveling?
Northbound on Andover Road.
So the same direction that you were facing initially, and then when you merged into the road.
That is correct.
Was the Nissan traveling quickly or slowly?
It was going 76 miles an hour in a 40-mile-an-hour zone. So quickly is I guess the answer.
Okay. All right. And
Excuse me, Mr. McNair, you said 70 and a 40?
76. You're right.
Okay.
And when the Nissan did travel past your patrol vehicle, how close was it, would you say?
So I'm going to be parked off the shoulder, probably about 2 feet off the roadway on the shoulder, and it was in the lane that passed me. So within probably 6 to 10 feet.
So, and I think besides your own senses, you mentioned some other specialized equipment to check the Nissan speed. What did you use again?
So at the time I was in my Charger, my prior patrol car. It is a stalker radar. It creates a audible tone to identify the speed, and then also a visual with the speed indicated on the box.
Do you use testing on the stalker radar to check that it's working?
I do. Prior to shift starting, I use tuning forks to make sure that the radar is working correctly.
Okay. Now, you mentioned that this tuning fork testing occurs prior to shifts, not every shift?
That is correct.
And what do you do if the stalker radar happens to not be functioning properly?
It'll give me a fail indication, and at that point, if it was to give me a fail indication that it wasn't working correctly, I would tell my administration to have it fixed and taken out of service.
Okay. So, does this stalker radar require daylight to work properly?
No.
No. And will it? So it will work properly even at nighttime.
That is correct.
So again, at the date and time we've already mentioned, was the stalker radar working properly?
Yes, it was.
Okay. And you know this because
I use the tuning forks to let me know that it's working correctly, and I did not get a fail illumination on the radar box itself.
Can you confirm that the Nissan was in fact clocked by the stalker radar?
Yes.
And how do you know that?
I don't know how the radar works per se. I know how to use it. I know how the conditions that I use it in. Like I said, it was on a rear stationary radar, facing to the rear. The vehicle came over the hill. As soon as the radar indicated the speed, I looked at it and I watched the speed reduce as the vehicle passed me. So I can definitively say that was a vehicle, and as it passed me, the speed stops being recorded, which lets me know that that's also the vehicle that just passed me and there's no more vehicles behind it.
Okay. Now, you've already mentioned that the vehicle was traveling at 76 miles an hour. What was the posted speed limit in this area?
40 miles an hour.
So a difference of 36 miles per hour when all is said and done.
With my math, yes.
What happened after you clocked the Nissan speed and you conducted the traffic stop?
So I conducted a traffic stop with the vehicle on Andover Road. At the time when I walked up to the driver, I told her what was going on. I said I used my radar to indicate she was speeding. She did not believe that. I believe she didn't think I could hear on my radar from where I was. I believe she had me confused with an Andover patrol unit that was coming up from the north heading south, that she saw pulled behind me. There was a discussion about her license being suspended, which was a misindication by my dispatcher. And I went on and gave her the citation, the notice to appear, and completed the traffic stop.
Okay. Now you've already referred to the driver's license of the driver of the Nissan. Is that how you identified the driver of the vehicle, by their driver's license?
Yes.
Do you see the driver of the Nissan present in the Zoom conference?
I can't attest to the small little picture there that I see, but I believe that is her, Jocelyn Whitmore.
Okay, so could you please give a brief description such as you are able?
White female. Yep, that appears to be her that's sitting there.
Your Honor, let the record reflect that the witness has identified the defendant.
The record shall so reflect.
Now you've already, I think you've already mentioned that you did discuss the defendant speeding, and she had indicated some confusion on her part.
Yes, she indicated to me, she questioned how I could have got her speeding when I wasn't behind her. She said, and I'm quoting off of my narrative that I'm reading here. You said, how could I have gotten her on radar? And like I said, I believe she did not see me. I was with my lights off the shoulder side of the road, and I believe she saw an Andover police patrol car coming from the north heading south, behind her, behind me, and thought that that was the car coming from north, which was down probably a quarter mile, which would make her think that there's no way that person could have saw her come over the hill at that speed. Which I think she failed to realize was that I was parked off the roadway to the east of Andover Road, and I pulled out behind her before conducting a traffic stop. Honestly, I don't think she even saw me when she came over the hill because of her rate of speed in that 40 mile an hour per zone.
And how was her attitude during this whole conversation?
Well, I don't want to repeat some of the stuff she said because of its court and it's public, but she was not happy with me. She did use some explicitives, and she had her children in the car, which she used those words in front of, and I advised her that that's probably not the best practice. And then she told me in not so many words that that's none of my business.
Okay. So there were juvenile passengers in the vehicle?
That is correct. In the back seat. One was unbuckled, one was buckled.
Okay, so, and how many did you say?
I believe there was two. I know there was a 4-year-old boy who was not buckled in his car seat, closest to me on the passenger side of the vehicle in the rear. Okay. And I asked him to put his seatbelt on, which his sister, who was next to him, said he always does that. I guess he doesn't ride with his seatbelt very often.
So, and ultimately you did write the defendant a citation for the speeding?
That's correct.
And then when you wrote the citation, did the defendant take the citation, I guess?
Well, as I said earlier, there was some confusion. She had a suspension pending 2 days later from my stop. It was in my system as suspended. From what dispatch told me at the time, I didn't have the ability to look on a tablet like I do now. Dispatch told me the license was suspended. So when I presented her with a misdemeanor notice to appear for a suspended license, she refused to sign it. I told her that if she wanted to refuse to sign the NTA, I would be inclined to arrest her and take her to jail, to which she was not very happy. After I believe I calmed her down quite a bit, she reluctantly signed the NTA, and then I completed a traffic stop.
And you referred to driving while suspended, potentially. Is that, what level of crime is that?
Misdemeanor.
Misdemeanor. Okay. So ultimately, the defendant did sign the NTA.
That is correct.
Barring any redirect, no further questions.
All right, Ms. Whitmore, this is your opportunity to ask questions of Deputy Maloney. It's not quite time to testify should you wish to do that, but if you have questions, you may ask them at this time.
Okay. Did you know that the speed limit actually went from 55 to 40?
I don't know what you're asking me.
The speed limit was not 40 all the way down that road. I was actually on a 55 zone.
Okay, now don't testify. Just keep asking questions.
Okay. Where I was sitting was 40, and that's where you were. Your speed was recorded. I guess is the answer.
Did
I
you
don't know
say
where that, I don't know where that road, whether the speed changes up and down the roadway. On Andover Road, it changes multiple times. At some point, it's actually 30 miles an hour. It's 55, it's 40. Where I was sitting, where my radar indicated you, the speed limit was 40 miles per hour, and I had radared you at 76 miles per hour.
okay? And you said you were sitting at the at the 40-mile-an-hour zone, but you said that you seen my speed behind you.
Your Honor, where my radar was set up, it was a 40 mile per zone. I don't know how else I can answer that question.
Do you want to ask another question or rephrase that question, Ms. Whitmore?
I guess what I'm asking is, do you realize that the speed limit was 55 before it went into the 40 zone?
I don't know where that's at on that road. I can tell you where I was sitting, it's 45, or it's 40, sorry. And if it's 55 somewhere else on the road, that may be, but where I was sitting, where my radar clocked your speed, where I sit every day and run radar, it was 40.
Okay, and then you said that you clocked me. Do you have proof of you clocking me whenever you said you got that speed? Do you have like picture proof or on a video or something?
Wow. It's a regular Perry Mason.
No.
It's Matlock.
Do not? Okay.
Hump number 8.
I do not believe I have any further questions.
Very well. Thank you, Ms. Whitmore. Mr. Regier, any redirect?
You got it in the bag, Regier.
So just to be clear, when you clocked the defendant's speed on Andover Road, what did you measure her at? One more time, please.
76 miles per hour.
No further questions, Your Honor.
Any recross, that is, you can ask a question based on what he just asked, but you have to limit it to what he just asked. Do you have any questions? Do you have any evidence at this time?
I do not have evidence, but I would like to give a testimony.
All right, that would be evidence. Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
All right. And you are the defendant in this case. How do you pronounce your name?
Jocelyn Whitmore.
Oh, Jocelyn Whitmore. Okay. And you are the defendant.
Yes, ma'am.
Okay. What would you like to testify to today?
Okay, so where the officer was sitting, I think where he described was pretty accurate. He was sitting right at the 40-mile mark where it just changed to 40 and it was 55. I do not know what speed I was going. I don't believe I was going 76. And that's why I asked if he had any proof of that or anything. Because if he did, then I would not deny that. But I don't believe I was going that fast. But I do know that I was speeding a little bit. But I was in the 55 and not in the 40 until I got up to him. That's why he said that I was actually slowing down the closer I got to him, because the speed was going down from 55 to 40. And that's why I was slowing down. And what he said about, I said something about, how did you clock my speed if you were there, or something like that. I actually asked him, like, how do you clock speed if I'm behind you? Like, because I was driving behind him. I don't know how that works. How do you clock the speed if you're behind instead of driving past someone, I guess is what I was asking. And then also when he first came up, I did not, he's acting like I was cussing him out with stuff. I did not. He walked up, and I'm actually very respectful whenever it comes to officers, and I've never had this issue before, and I've had a few speeding tickets before. And I have never denied to sign anything or anything, because I've never thought that I was in the wrong. But when he first came up to my car, he said, you were going 76 in a 40. I said, well, I'm not in a 40, and I don't believe I was going that fast. And then that's whenever he just asked me for my information. And I just told him, I don't think I was going 76, is what I told him. And then I gave him my license and everything. Well, he went back and he did all that stuff back there. Then whenever he came back around, he said, your license is suspended or something. And so I was surprised because I didn't know my license was about to be suspended. And so that's whenever I was like, what the F, are you freaking kidding me? And then he's like, you need
Your Honor, objection relevance. The only charge before this court is the speeding.
Well, your witness testified about it. I'll let her talk about it.
But anyways, I showed a little bit of upsetness, and he said, you need to watch your mouth in front of your kids. And I was like, you don't tell me to watch my mouth in front of my children. And then he says, well, you're getting irate. I'm like, I'm not getting irate with you. I'm upset because you told me my license is suspended and I didn't even know anything about this. And so I was upset about that. And then he's like, okay, well, you need to leave your car here and you need to find a ride. And I was like, at 5 a.m, where am I going to find a ride at? And so he walks off. I have to call and find a ride. He told me to leave my car there. He did not mention that he was going to tow my car or anything. He took my license, went back to his car, and then came back and was wanting me to sign the paper. Well, I was like, well, you're wanting me to sign paper admitting that I was driving 76, and I don't believe I was driving 76, which, like I said before, whenever I've gotten tickets, I've like willingly signed it because I knew that I was speeding and I knew what speed I was going. And I thought signing it meant like you were guilty. And that's what I explained to him. I was like, I don't think I'm guilty. And that's whenever he started saying he's going to take me to jail if I don't sign it. And I was like, you're going to take me to jail for not signing paper? And he's like, yeah, you have to sign it. And I was like, that makes no sense. And why are you threatening to take me to jail in front of my kids? And he's like, well, you can either sign it or I can take you to jail. And then he was like, whenever you sign it, it's not admitting that you're wrong. It's just saying that you're going to show up or call before the state. And I was like, okay, well, you could have explained that before. You said you were going to take me to jail. I'll sign that now. I didn't know that's what that was for. And then I signed it. And that's why I calmed down, because he actually explained it to me. And then after I signed it and everything, I had to call for a ride and everything. And whenever we came back to get my car was gone because it had gotten towed. He took my license and everything. And come to find out, my license wasn't even suspended to begin with. And so he took my car and my license. I don't know if dispatch really told him that. All I know is he was not being very nice to begin with. And he took my car and my license. I don't know if he was upset that I denied that I was going 76. I don't know. But ever since I denied I was going 76 is whenever he like wanted to take my car and all of that and did not I don't know. It was just a mess. And all I know is I don't believe I was going 76, and I definitely was not in a 40 zone. I was in a 55. But that was pretty much the whole story. And then also they said they were going to do an investigation for the whole thing, but I haven't heard anything back from that.
And who do you mean when you say they were going to do an investigation for the whole thing?
His office, like the sheriff's office.
Okay, so you'd filed some kind of complaint about him to his superiors?
Yeah, I called
his
them.
Administrators? Okay.
And they said they were going to do an investigation. I don't know if they ever did, but that's what they told me.
Okay. Anything else you'd like to say?
I don't believe so.
All right. Mr. Regier, any cross-examination?
Nothing from the state, Your Honor.
All right. Any further witnesses or evidence, Ms. Whitmore?
No, ma'am.
All right. Sounds like both parties have rested. Ms. Whitmore, based on the officer's experience and testimony that this is where he sits and does this job every day, or nearly every day, I do find his testimony to be credible beyond a reasonable doubt, I find you guilty. Your fine is $285. Your court costs are $108 for a total of $393. You can appeal this for up to 14 days from this hearing. If you do appeal it, your appeal bond will need to be $393. There also are suspension fees. I should say reinstatement because you took so long to take care of this. Yeah, your license apparently was reinstated or revoked. No, that's not right. Suspended. So, Ashley, where does this 393 come from on here?
I don't show that she's suspended. 393 is the fine amount and court costs.
Oh, okay. Well, that's the good news then. You're not suspended again. That's twice you've been told you were suspended and you weren't. All right. So when can you pay the $393? Do you need some time for that?
I definitely need time for that.
How much time do you think you need?
Is there like a payment plan that I can set up or something?
What I usually do is you tell me how long it's going to take you to pay it. I set it for that date, and then you pay as you need to make it work. So,
can I get like months?
How long?
6 months.
No, I can't quite go that long. I was kind of thinking maybe July, sometime in July. This is April to May, June, July. That's about 90 days. We could set it for 90 days and see how close you are.
Okay, that's fine.
But you really need to get it paid as soon as you can. What do you have in July for us, Ashley, around?
Do you want a Wednesday morning?
Probably Wednesday afternoon because Wednesday mornings are so busy.
A Wednesday afternoon?
I think so.
Let me look.
Which hopefully she'll have this paid.
How about the 12th?
Okay, that's exactly 90 days, I believe. This is April 12th. We'll have it July. If you don't have it paid by July 12th at 1:30, you need to be back here by Zoom. If you have it paid, then you won't need to come here.
Okay.
But if you don't have it paid, I need to make sure that you've been making good faith efforts at it.
Okay.
And certainly don't want you to get any more violations during that period of time. And as I said, you can appeal this for up to 14 days, but if you appeal it, you'll need to put that $393 as a cash bond.
What's appeal?
That means if you don't like the decision and you think I made the wrong decision, you can go file at the clerk's office a notice of appeal, and you can file an appeal to challenge my decision with the Kansas Court of Appeals. You have to know how to do it if you're going to represent yourself, or you have to hire an attorney.
Okay.
All right, Mr. Regier, anything further for the state?
Regier.
Nothing from the state. I just want to thank Deputy Maloney for his appearance here today.
Yes, sir. Thank you for honoring that subpoena. And thank you, Ms. Whitmore, for honoring your obligation to be here. Is there anything else I can help you with before you leave?
I don't believe so.
Okay, and you make your payments at the clerk of the district court. If you want to pay online, you can call them and they'll tell you how to do that.
Okay.
All right.
Okay, people, here we go. Bonus clip. We got 335, 331 in the room. You guys never want to leave. I never want to leave you. But we have a kitchen court case to take care of. I heard she's doing detention hearings. So, without further ado, I am going to play a bonus clip because you voted for Karen's last night. So we are going to give our final hump of the night. We are keeping HumpSday in effect. Hump number 9 will not disappoint, I promise. Thank you, Mark Baggett, for another one. Mark Baggett is going to be a staple on this channel. He is awesome. Here we go.
Go tell me. Hi.
Okay, you need to leave, man.
He's being rude. You're being
No,
rude.
I'm not being rude. You need to leave.
I'm buying something.
No, you don't want any more customer. You need to leave.
Oh, I'm not a customer?
You're not
So then I
customer
want my
in this store.
thousands of dollars I spend here back every day.
You spend thousands of dollars at Home Depot every day? I'm gonna say you're lying about that.
No, leave.
Leave.
You need
So
to
then
leave.
give me my thousands of dollars. Give me my thousands of dollars.
No, leave.
Give me my thousands of dollars back.
Oh, wait, you serious? Let me laugh even harder.
Then give me my thousands of dollars back.
Out.
Cool, you're getting fired.
Bye.
Fired.
Go.
Fired. Fired. I said, I'm not leaving. Call the cops. I've done nothing wrong. I'm trying to buy something. And he's like, I'm not discounting anything. I'm not selling you anything. Get out of my store. Like pushing me out. Like walking me out. Not touching me, but like pushing me basically out. And then I turn around and you're gonna be rude. Go back to your country.
Like all Karens, she didn't start recording until she was being thrown out of Home Depot. But if I had to guess, she was probably the one being rude and verbally attacking the employees. Who are you to be telling anybody to go back to their own country? It's people like this woman who make the world a bad place.
Go back to your country. Because he wasn't from here. That was it. And I mean this sincerely. For all the people in the back, if you ain't gonna fucking respect Americans, go back to your country. Respect is earned, not given. Don't be fucking rude and work in customer service, for one. So I turn around, I say go back to your motherfucking country and learn some fucking manners before you come here. Whatever the fuck I said, spitfire, as always, you know how I do. That
She
was
sucks.
fucking it. Get out of here, you fucking cunt. Go back to your country. Yeah? You ignorant. Go back. Yeah, you do this, you fucking cunt. Yelling, screaming at me. So I finally pull out my phone. I'll show you the end of it. Here's the video. Been on the phone in the parking lot still with customer service complaining because that's not how we treat customers. So Mr. Hansen and Jamie are going to lose their job today.
I guarantee you that didn't happen, especially after this video went viral on TikTok.
This is what happens when we fuck with Amanda Marie Keshner. Okay, bye.
We've all heard the saying that the customer is always right. Well, I believe that saying is completely false. In reality, the customer is almost always wrong, and this woman is a perfect example of that. I did find her YouTube channel, and people in her comments are calling her out on her behavior. Hopefully, she was banned from Home Depot.
Art
I would like to
Bandro.
give a huge shout out to all of my channel members for you.
Well, there it is, people. Another unbelievable show. I just want to say thank you to everybody. Thank you for your support. We had a great, unbelievable show. Thank you to Sean Wexler and everybody else who donated and everybody who has ever donated to me and anyone who even watches my channel, gave me a view. Make sure to hit that like. Done anything to support this channel. Even said you don't like me, you're still supporting the channel. I don't care. You guys are the best. Make sure you go to Kitchen Court Cases. She is the perfect nightcap for a court nerd. See you guys later. You've been served, nerd.